Okay.
Okay, Commissioner Newton? Commissioner Newton? Oh, he's not here, huh?
Yeah, I don't see Clay yet.
Okay. Commissioner Patrick?
Yes.
Commissioner Burt?
Yes.
Commissioner Bennett?
Yes.
Commissioner Kerr?
Yes.
Commissioner Knopf?
Yes.
Chair Johnson?
Yes. Are there any amendments to the minutes in last month's meeting? Okay, if not, is there a motion to approve the minutes?
I so move.
Second.
Okay, call the roll.
Commissioner Patrick? She gives me a thumb up. Okay. Commissioner Burt?
Yes.
Commissioner Bennett?
Yes.
Commissioner Kerr?
Yes.
Commissioner Knopf?
Yes.
Chair Johnson?
Yes. This is a quasi judicial hearing regarding public hearing and consideration of V21-02, Jay Rashkin request on behalf of Stan and Becky Roberts for a variance of the oceanfront setback for the construction of a new residence. V21-02, Stan Roberts application for a variance to reduce the oceanfront setback from 119.1 feet from the stationary vegetative line to 87.6 feet, according to the chapters in 17-42 Oceanfront Management Overlay of the Municipal Code. The property is a vacated lot located north of Nana Avenue, west of South Hemlock Street, tax lot 600, map 51031AA, in residential low density zone. The request will be reviewed pursuant to the municipal code section 17-84-030 variance criteria for granting. Does anyone object to the jurisdiction of the Planning Commission to hear this matter at this time? Does any commissioner member believe he or she has a conflict of interest or personal bias? Has any commissioner member had an ex parte contact or made a site visit?
Site visit.
Site visit.
Site visit?
Yes, site visit.
Okay, staff report?
Yes, I'd like to at least first say that we've received quite a bit of information or new evidence, and from Mr. Rasmussen, we received some hard copies with that are let's say exhibits to his letter. You have in your packets the letter, but we have not had the opportunity to distribute the hard copies of those. We will get those out to you. We'll also post that. We also have had 4 or 5 emails after 5 o'clock of new information from the applicants that I would assume that they're going to speak to in their presentation. So I just wanted to let everyone know that we haven't been able to compile that and get that out to the Planning Commission since we've received them. So for the staff report, I'm going to share my screen here. And walk through the staff report and try to also keep an eye on the Zoom meeting to allow if Clay shows up and other participants want to show up and let them in. But This is, let me get to the background. Jay Raskin, on behalf of Stan and Becky Roberts, are seeking a variance for reduction of the oceanfront setback of 31.5 feet from the 119.1 feet from statutory vegetation line as required by Chapter 1742 Oceanfront Overlay to 87.6 feet in order to build a single-family residence off Hemlock Street by way of Nanana right-of-way. The applicants recently applied for a development permit and building permit to allow construction of a home on the site without a variance, and that permit resulted in multiple administrative appeals involving compliance with Section 174250A6 of the Cannon Beach Municipal Code, obtaining a setback reduction or variance to comply with the CVMC. Planning Commission on November 17th, 2020 concluded that the application did not comply with the oceanfront setback and the application was denied. The applicants filed an appeal on November 25th, 2020, and a hearing was held before the Cannon Beach City Council on December 11th, 2020. After the hearing, the City Council upheld the Planning Commission's decision. There's Clay. Clay is now in the meeting.
In the building.
And they upheld the decision. The 5,394 square foot residential lower density lot abuts the ocean shore as explained below, and the Nanana Street right away off of the S curves of South Hemlock. Property is considered in the oceanfront management overlay zone as a lot abutting the ocean shore, as the CBMC defines the term. A lot which abuts the ocean coordinate line, or a lot where there is no buildable lot between it and the ocean coordinate line. The residential low density zoned areas are held to a net density standard of 4 dwelling units per acre throughout the city based on the capability of the land in terms of its slope potential for geologic hazard and drainage characteristics. Property's closest neighbors are approximately 60 feet to the north and 100 feet to the south. 100 feet to the east, with approximately 3 units per acre for RL zoning districts citywide. The variance criteria are in the staff report. I will just jump down to the actual staff comments and highlight those comments. Under the comments for the oceanfront setback and the general standard for the applicant request, the applicant generally explains his reason as cannot build a reasonably sized dwelling structure on the subject property due to the city's strict interpretation of the oceanfront setback. The lot's real market value is nearly $1 million. The development costs for this lot to date are extremely high, as calculated by the city and in conjunction with other setbacks. The oceanfront setbacks, as interpreted and applied by the city, reduces the buildable footprint of the Roberts residential subdivision lot from 2640 to 700. Staff's comments are, the applicant states that the oceanfront setback reduces the buildable footprint to 700 square feet, which accounts for a highly unusual 73% reduction in the buildable footprint compared to the setback standard of 15 feet. The applicant also states that such an oceanfront setback would account for one of the largest ocean setbacks, if not the largest ocean setback in the city. Although this may be the largest oceanfront setback in the general Haystack region, this isn't the largest in Cannon Beach. There are a number of homes on the Cannon Beach shoreline with oceanfront setbacks over 100 feet. For instance, in a GIS analysis of the Chapman Point area, the average oceanfront setback for all the properties along the ocean shore is approximately 102 feet. And I highlight just one that was the largest, around 190 there, and then just showed a example of that Chapman Point. The applicant points out that this case is unusual because there's only one building within 200 feet north and south of the subject property. The city has interpreted that in a manner that allows the city to take an average of one building. We assume for purposes of this variance only that interpretation of the city code and seek a variance of the oceanfront setback that interpretation yields. From the oceanfront survey presented, Exhibit A5, one can see that the Haystack LLC property to the north is the only structure included in the OSL calculation, which falls within 100 feet from the subject property. The standard only goes to the 200-foot range when a structure isn't found in the 100-foot range. Staff survey of oceanfront lots in Cannon Beach finds a number of lots with only one structure found within a 100-foot range, including a number in the Chapman Point area. It might be more appropriate to say that there are a few within Cannon Beach and no others in the Haystack Rock lower residential zoning district. That a strict or literal interpretation and enforcement of the specified requirement would result in a practical difficulty or unnecessary hardship and would be inconsistent with the objectives of the comprehensive plan. Staff comments, as discussed below, the hardship identified by the applicant is that a home allowed under the oceanfront setback is smaller than the home desired by the property owner. The Cannon Beach has a number of homes, including oceanfront homes under 1,400 square feet in floor area as a practical standard. A GIS analysis of Cannon Beach homes shows that the median square footage of all single family dwellings is 1,564 square feet, while the mean is 1,752. The applicant states that the application of the oceanfront setback creates a practical difficulty because it makes it impossible to build an economically viable home large enough to house a reasonably sized family. Staff would note that the U.S. Census American Community Survey estimates that the average household size of Oregon is 2.51, while Cannon Beach has just 2.19 per household. The applicant makes a number of claims regarding hardship, including the resulting small dwelling does not provide any reasonable return on the applicant's investment in this lot. We are aware of no other new houses in the city that have been built at this small size, particularly not on an oceanfront lot of such high value as here. There are approximately 700 homes in Cannon Beach that are under 1,400 square feet. In addition, along the Haystack area oceanfront, there is one home, 1,450 square feet, 3 properties south of the subject property, and another 1,502 square feet, 2 properties to the north, built in 1940 and 1955, respectively. In the city of Cannon Beach, there have been 60 homes under 1,400 square feet built since 2000, with the most recent built along the ocean shore in 2016 at 3543 Pacific, 1,366 square feet. The applicant also states that any resulting dwelling would be more akin to an apartment-sized unit typical in high-density residential zones, as opposed to dwelling typical in the RL zone lands. The typical or median-sized home in citywide RL zone district is 2,152 square feet and a mean of 2,360 square feet, while the median home in the Haystack RL zoning district is 1,913 square feet with a mean of 1,959 square feet. While the Clatsop County Assessor's data utilized by the city's GIS analysis doesn't offer the ability to track multifamily based on the 2 largest complexes, Elk Creek Terrace and Shorewood, the average apartment unit would probably be more in the 900 to 1,000 square foot range rather than 1,400 square foot. To continue their hardship request, the applicant states that the reduced buildable footprint will result in a dwelling that is not commensurate with the zoning or the lot size or reasonably capable of accommodating their needs or returning any reasonable value or possibility of return on their investment. The Planning Commission must determine if this 73% reduction in buildable lot area creates an unnecessary hardship and would be inconsistent with the comprehensive plans. As noted above, there are multiple small cottages built along the oceanfront in Cannon Beach, even in the Haystack RL zoning district, but they were built prior to 1970. Whether the PC ventures into return on investment in their analysis of hardship, there's a growing trend towards larger homes in Cannon Beach and along the oceanfront. The applicant draws a distinction between pre-1970 oceanfront units versus post-1970 and concludes, according to Exhibit 1, that the improvements for pre-19 homes 70 homes in their study area between Center Street to the north and near the Gagana Street to the south accounted for just 7% of the real market value, while those after 1970 accounted for 28%. When one looks across the city at homes built pre-1970, the 549 single-family homes analyzed have a mean of 1,450 square feet with $153 of improvements per square foot as compared to 1,900 homes built post-1970, which have a mean of 1,900 per square feet per home and $213 of improvement per square foot, or an increase of nearly 40% improvement values alone. Item 2, or criteria 2, that there are exceptional or extraordinary circumstances or conditions applicable to the property involved or to intended use of the property which do not apply generally to other properties in the same zone. Staff comments. The applicant has stated that the strict interpretation of the oceanfront setback presents exceptional, extraordinary circumstances. They've argued that it results solely from one, arbitrary location of the only house to the north within 100 feet distance from the Roberts lot, and two, the arbitrary location of the state's so-called vegetation line. For instance, if one were to take a minimum setback required by the Oceanfront Management District standards of 15 feet rather than 0 for the vacant properties falling within 100 feet reached to the south and north, the subject property would have a 67-foot oceanfront setback line rather than 119 required. Or if we were to take the haystack area average, the applicant would have an oceanfront setback line of 61.4 feet. There is no question that when the property directly to the north at 1981 Pacific Avenue rebuilt after burning down in the 90s at its previous location, rather than where the OSL and other geohazard standards might have allowed, it would by all accounts provided a more western OSL for the subject property than that contemplated today. But this doesn't change the fact that the neighbors chose to build their house where they did, and that under the city's oceanfront setback standards, that has implications for the applicant. In the same way that had the applicant built first, his choice of location would have had implications for his neighbors. The interesting proposition that has not been explored by the applicant, yet would offer at least 140 square feet of buildable area to the footprint, an additional 280 square feet to the FAR as a southern variance to within 5 feet of the property, Nanana Avenue property line. In other words, expanding south, which is not, they have not asked for. Presumably, the reason a setback reduction under 1764 wasn't sought to the north, south, or east may have been due to other priorities, but it should be noted that these setback areas offer up to approximately 650 square feet of additional building envelope and 1,300 square feet towards FAR without the need for a hardship variance. Although 1764 10H specifically speaks to permitting construction on an oceanfront lot where the effect of the application of the oceanfront setback requirement, section 174250A6, reduces the depth of the lot located within the required setbacks to less than 40% of the lot's depth. Under this standard, a reduction in the required setback shall be considered only in the setback opposite of the required oceanfront setback. The other options under CBMC of 1742 of setback reductions to the north, south, and east remain. On criteria 3, the granting of the variance will not be detrimental to the public health, safety, or welfare, or material injurious to properties or improvements in the near vicinity. Staff comments. As was stated when the previous application came before the Planning Commission for this property, whether this is a buildable lot is not at issue in this variance request. The Cannon Beach Municipal Code and the Oregon Building Code require that all structures meet the geohazard requirements of 1750, which assures the public health, safety, or welfare will not be placed in jeopardy by this variance request. The city also assures that any access onto South Hemlock via the Nanana right-of-way will meet Chapter 1234 of the Cannon Beach Municipal Code road standards and abide by all local and safety standards prior to approval. The subject property was a lot of record created by the 1908 Tolovana Park plat, which was to be accessed via Nanana Avenue and Ocean Avenue. That's dedicated thoroughfares forever. The applicant states traffic studies have shown that providing access to the Roberts property show no potential harm to nearby properties, and continues by saying access to the site remains the same whether the setback reduction is granted or not. This, however, isn't entirely accurate, as this plan, as opposed to those on file for the previous application, show a ground floor approach, driveway and garage, while the initial plan showed an elevated approach and public roadway leading to a second-story garage. Although the city has received traffic studies comporting with the initial roadway plans as of this, the city has no studies of the approach as found in this plan. In other words, the city will require further traffic studies for this new approach before approving access. It should be noted, however, that each of these, whether geohazard or traffic analysis reports, are not necessary and not expected to process a variance request. Mr. Rondema has stated that the geohazard improvements proposed by the plans would help stabilize the subject property and shore up the surrounding S-curve area from the threat of potential slides. Although there is evidence of a foundation for a structure existing on the subject property, the applicant hasn't provided any documentation of the previous dwelling. The city has searched its files on the property and finds no building permits still on record or other evidence that might provide any details. Number four, the fourth criteria, the granting of the variance would support policies contained with the comprehensive plan. And the four comprehensive plan policies provided there. Staff comments, the applicant points to the flexibility of general development policy 16, housing policy 11 of the Cannon Beach Municipal Comprehensive Plan, and the granting of the variance to support policies contained within the CBCP. The site design and geologic hazardous policies of the CBCP are appropriate policies to consider in finding compliance with the comprehensive plan. However, it should also be noted that general development policy 6 might be the most appropriate. The scale of the residential development shall be controlled in part through standards for lot coverage, maximum gross square footage. This policy speaks most directly to the applicant's concerns at the 73% reduction in buildable lot area places an undue burden on the property owner. B, variances in accordance with this section should not ordinarily be granted if the circumstances on which the applicant relies are a result of the actions of the applicant or owner or previous owners. Staff comments. The Planning Commission must weigh whether the applicant's request is not a self-imposed hardship or difficulty, since no actions have been undertaken by the Roberts or the previous owners that have changed the size of the lot or negatively impacted the development of the property. The Roberts bought the subject property according to the Classic County records in 2001. The oceanfront setback for oceanfront lots was established in 1994. As the applicant states, they or the previous owners have done nothing to change the property, yet neither has the city or anyone else. This appears to be an argument based on special circumstances where a home cannot be built on a property to meet the needs of either the applicant or the market. Staff comments on the conclusion where the applicant states the proposal seeks a modest reduction of the oceanfront setback of 31.5 feet from 119.1 from the statutory vegetation line to 87.6 in light of the fact that the grant of the setback would have no appreciable impact on the ocean views experienced by the neighbors to the north. Of variance should be granted. Staff comments. A variance provides relief when a strict application of the zoning requirements would impose unusual practical difficulties or unnecessary physical hardships on the applicant. Should the Planning Commission decide to grant the variance, CBMC 1784-20 allows reasonable conditions to be imposed in connection with a variance as deemed necessary to protect the best interests of the surrounding property or neighborhood, and otherwise secure that purpose and requirements of this chapter. Guarantees and evidence may be required that such conditions will be and are being complied with. If so, the Planning Commission should consider whether any additional conditions that it deems necessary to protect the best interests of the surrounding property or neighborhood. I have supplied the conditions that were previously placed on development permit and also would be applicable for this. Any questions from anyone? Oh, Lisa?
Do you have,
Yeah, I think Lisa had a question, but
do you have a question, Lisa?
I do.
Okay.
I want to know why information is coming in, new information, an hour before the meeting. Isn't there a deadline on when new information will be admitted?
So the part of the purpose of the hearing is to allow people to introduce evidence and make their arguments. And so there is an expectation that new information will be coming in. Certainly, some people try to get in early to make sure that you have an opportunity to review it, but there's no prohibition on somebody introducing something an hour before the hearing or at the hearing itself.
Okay. So we don't get a chance to review it.
And we can talk about this when we get it there, but there might be an option to take information today and then, allow either additional information to come in or not before your next meeting and make the final decision at your next meeting. So you have plenty of time to review what information came in, digest it, and come to a reasonable review of that material.
Okay. Thank you.
Clay, can you hear us?
Yeah, can you hear me okay?
Yes, thanks.
Yeah, I apologize for being late.
No problem.
Okay. The pertinent criteria to be considered are noted in the staff report and listed on the criteria sheet on the meeting page of the city website. Testimony, argument, and evidence must be directed towards that criteria or other criteria in the comprehensive plan or municipal code which the person testifying believes to apply to the decision. Failure to raise an issue accompanied by a statement or evidence sufficient to afford the decision makers and the parties an opportunity to respond to the issue precludes the appeal based on that issue. Prior to the conclusion of the initial evidentiary hearing, any participant may request an opportunity to present additional testimony, argument, evidence regarding the application. The Planning Commission shall grant such a request by continuing the public hearing and leaving the record open for additional written testimony, argument, and evidence. Persons who testify shall first be recognized by the chair, state your full name and mailing address, and if appearing in a representative capacity, identify who you represent. So the main applicants, we are going to limit the testimony to 15 minutes. And so is there a presentation by the applicant?
Andrew?
Yes, Jay Raskin has our PowerPoint, so hopefully he's able to.
Okay. Let me get Jay here, okay? Jay, can you hear us now?
Yes.
Okay.
Can you hear me? That's
Yes. And would you like to share the screen as well?
Yes, I would. Let's see how this works.
Okay, let me see if I can.
Okay, there we go. Yeah, does everyone see my screen?
Yes.
Yes.
So good evening. My name is Jay Raskin. I'm the applicant and I represent Stan and Betsy Roberts. My address is 2418 Southwest Troy Street, Portland, Oregon, 97219. I'm here with land use attorney Andrew Stamp, whose address is 4248 Galewood Street, Lake Oswego, Oregon, 97035. We are making this variance request because we listened to the feedback that we received from the city during the last land use application. Both the city council and the planning director have encouraged the applicants to apply for this variance, and so here we are. We also listened to the feedback we received regarding the elevated bridge structure to access the house. No one liked the building, including us, so we made the proposal. Since we made that proposal, the city public works staff has indicated that they would prefer to see as close to an at-grade driveway as possible. So as part of this variance, we are showing a conceptual driveway access that results in a ground floor entry. The access is not part of this variance proposal, but it does show conceptually how we would feasibly access the property without the elevated bridge. Oh, let me, so I don't. There we go. Yeah, and this is the vicinity map that shows the location of the property, which is right here. Let's see if I can do this without, which is right here. And that's Nana Street, that's Hemlock, and then here's this Ocean Street down below. The green line right here is the Oregon vegetation, statutory vegetation line. And the zone here is basically the analysis that we did with, which according to the variance criteria was asking for people looking at houses in the vicinity and in the zone. So we didn't include Chapman Point in this analysis because it's actually was developed as a subdivision with building envelopes, and none of the houses there basically go through the oceanfront averaging process for siting. And so all these are RL zoned, and they're also oceanfront. We didn't consider RL properties that basically weren't oceanfront because we're talking about an issue that deals just with oceanfront properties. And Andrew is going to talk to you more about the variance criteria. There we go.
So this is Andrew Stamp for the applicant. If you could go back to that third slide, please, Jay. So the purpose of a variance is to provide relief. An escape valve is what courts call it sometimes, when strict application of the zoning requirements would impose an unusual practical difficulty or hardship on the applicant. There's 5 criteria that we have to address. The staff report went through them, and so I won't belabor them too much, but you can see them right there. The applicant has to establish some sort of practical difficulty or unnecessary hardship. Those are slightly different but related standards, and the applicant has to only have one of the two. The exceptional extraordinary circumstances, the second criteria, and the idea behind this criteria is that it's not that the circumstance is not something that generally applies to other properties in the same zone, that it's fairly unique to this property. The third standard is that granting the variance wouldn't be detrimental to the public health, safety, or welfare, or would not materially injure properties improvements in the near vicinity. And we've defined near vicinity in our application. We looked basically at the houses in the neighborhood. And materially injured is a serious injury or harm. It's not something that's just mere inconvenience or a trifling small effect on a property. The fourth criteria, we have to support policies contained in the comprehensive plan, which staff discussed. And then finally, we have to show that the circumstances which we're relying on for those earlier criteria are not a result of actions that we took or that our previous owners took. And so with the next slide, Jay, I wanted to talk about the first of the 2 criteria, and we're really addressing these together because they're related. The focus here is on exceptional situations which result in practical difficulties or hardships, which are unique to properties that don't occur to other properties in the same zone. It's unique to our property. In this case, we would normally have a building envelope, a building footprint of 2,600 square feet, 2,640. But when you apply the oceanfront setback, that gets reduced to 700 square feet. It's a 73% reduction in buildable footprint. And that's very unique to our property. Most other properties do not result, the oceanfront setback applying to them does not result in a very big reduction in the buildable footprint. Jay, if you could get the next slide. And what you, Jay, you handle this slide, I think. Go ahead.
Yeah, so this basically, we looked at essentially what's the buildable area, the area that's defined from a lot that's with the setbacks. So the one above, the standard corner lot setbacks, basically this is a corner lot, even though Ocean Avenue doesn't exist as a street, it's considered a platted street for these purposes. So we would have 15 feet from Ocean, 15 feet from Nanana, and then a rear setback of 5 feet and a north setback of 5 feet as well. So when you factor in the oceanfront setbacks, this is the 119 feet, which basically shows you how much of the potential buildable area is impacted.
I think we can go to the next slide. So another one of the criteria that we have to deal with is we mentioned the material injury to other properties standard. And what I wanted to emphasize here is what the baseline for analysis is. What I saw some comments from opponents were really using the baseline as no development versus development of a home with a variance. And that's not accurate. It's not the way that you analyze this. What we show here, and Jay, if you could highlight the buildable footprint of the house without the variance down at the bottom, if you could put your cursor on that. The buildable footprint, the area that we could build on, the little tiny area right there, 700 square foot. So regardless of whether the variance is approved, we could still build in that footprint. It's a very small house, obviously. It would be limited to 1,400 square foot, and that would include the garage space and staircases and everything else. So it would make it essentially an apartment size unit once you got rid of those areas. But if we allow the variance, if the Planning Commission were to allow the variance, Jay, if you could highlight the above buildable area, what you'd see there is we could build on that additional land. And so the baseline is the bottom slide there, and the increased impact is what's created by the dark area on the top slide. And so when you're analyzing variances, that's really what you limit yourself to. What could you build without the variance? What could you build with the variance? And what you see is that the impacts are quite limited. There would obviously be some amount of increased impact on the house to the north from a view standpoint, and there might be some stormwater impacts because a larger house would create additional stormwater impacts, but the access would be the same. In other words, you'd still have the driveway in the same location. You'd still have the point where it hits the Hemlock Street would be the same. So none of those issues change. And so it's really important for me to emphasize how limited the analytical framework is in this case for impact. Jay, the next slide, please.
Yeah, I wanted to add something that I forgot in my slide when I was showing.
Okay.
It's very important to know that in the analysis that we did in the zone, every other property basically could develop itself to the maximum floor area ratio of that lot. And which is a distinct difference between what would happen on this lot, which is basically there would only be 1,400 square feet for.
Okay, Jay, let's go to slide 7. And you were going to handle this slide since you drew it.
The view arc of the neighbors. We wanted to find out what sort of impact our house would have on the view, and primarily that's to the properties to the north. So he said, basically, it's by itself on a very large piece of property. It's basically a view arc of over 130 degrees that ranges from Haystack Rock all the way down to the south. And the other thing is that we showed down at the bottom is that we would be cutting off a portion of that arc, but it's not at all clear what that actually would cut off. And in photos and in most things, Haystack Rock is kind of the main element for people talking about views on the beach.
If I could add one thing here, you can see the difference in the view is that blue slide. Jay, if you could come back to that. Yeah, right there. It's about, it looks here somewhere in the 5% range right there. Is if we were to have the variance granted, there'd be about a 5 to 10% loss of the arc of view there. Now let's go to the next slide because I want to show you what the neighbors submitted. This is the neighbors' perception of the impact to their review. Now this photo montage is utterly devoid of any science or any reality, frankly. They've made a number of analytical mistakes when they try to superimpose a drawing of the proposed home to an existing photograph. First of all, they use the wrong scale. The dwelling in this that they've used, they've scaled that out as about 3 times as big as the dwelling really is, which makes it appear much closer than it is. As a matter of fact, the way it's drawn, they've drawn it as if it's on their property. And that's the second thing they do wrong, is they choose the wrong location. The building is placed roughly 80 to 90 feet closer to the ocean than what is reality. This photo montage literally shows the building being set on the Haystack Rock property and on city right-of-way. And we'll show you in our next slide how we know that. And third, it's the wrong perspective. You simply can't superimpose a 2-dimensional elevation view of a structure onto a photograph showing 3-dimensional perspective and expect to get an approximation of reality. So let's just show compare their perception of reality to objective reality. This slide shows really what the home would look like to our best estimate. Now, there are some variables that we can't control. For example, we didn't know exactly where this photograph was taken, but we were able to triangulate it pretty well based on some geographic landmarks that we found in the distance. And we triangulated back to a single location to provide a pretty good estimate of where that location is. That's a technique we used in the military a lot, make sure that we didn't get bombed. So I was pretty familiar with how this works. Jay, if you could highlight that dead tree cluster right there. Okay, that dead tree cluster is located on city right-of-way. It's not even on our property. So there's no way that our building could block the view of that tree cluster. But go back a slide, Jay, if you would, please.
So your time is coming up to an end.
Okay, we'll try to hurry here. You can see there, they've shown that blocking, and we're certainly not going to block that. Okay, we'll move quickly to the next slide. Jay, if you could go to slide 10.
So this is an image of what the house looks like on the site. It shows the driveway coming down and much less impact than it had before.
All right, Jay, next slide. Regarding the policies that support the comp plan, what I'd like to say here is that the comp plan repeatedly talks about providing flexibility in the application of regulations governing site design. And really that's what a variance does, is it provides flexibility for when you want to, it provides flexibility so that if you have a unique situation on a lot, that you can still build your development by getting the variance. And Housing Policy 6 speaks directly to that, talking about striving to accommodate new residential development and doing so in a manner that's sensitive to the scale, character, and density of the existing residential development patterns, which we've done here, and to provide flexibility in regulations so that developments can be adapted to specific site conditions. We have a unique set of site conditions here, and that's what we're trying to do, is get that variance to get flexibility. All right, next slide. And I think this is the last of the criteria. The only thing I'd like to say here with regards to the this criteria is, contrary to statements made by the opponents, notice of existing regulations at the time you purchase a property is not relevant to this criteria. The criterion speaks to actions taken, not knowledge, and no actions have been taken in this case. But the knowledge that the applicant had when he bought it was that there was a residence that previously stood on the property. So it was very reasonable for him to think that a new residence could be built at that exact same location. Finally, I'd like to point out that the city of Cannon Beach has previously granted variances despite the fact that the hardship was self-created by the applicant. And what the code says, it should not ordinarily be granted, but the city does have the discretion to grant variances even in situations where there was some sort of self-creation of the hardship. And LUBA upheld that standard in the application and interpretation of that standard in Cope versus City of Cannon Beach.
Okay, you're running past your 15-minute time limit.
Okay, thank you very much, sir. I think that we'll close it up with that. Jay, is there anything you else wanted to say in closing?
No, I think we're good.
All right, well, thank you, sir, for allowing us the 15 minutes or slightly over to address these criteria. We appreciate it very much.
Okay, thank you.
And Jay,
Yes.
could you send me that presentation as well?
Yes.
We will.
All right, thank you.
Okay, are there other presentations by proponents?
And let me just ask Andrew or Jay, did Stan want to speak?
Stan's here. I saw him earlier at some point. Let's see.
We did not get a notice that he wanted to, but I did see him earlier on the call.
Stan, would you like to say anything tonight?
Given that we're limited to 15 minutes and we've already used a little bit more, I'll just keep it at that.
All right, thank you, Stan.
Okay. Okay, if there are no other proponents, then are there presentations by opponents?
Looks like there's a question, sir.
Yes, Lisa. Okay, just 1 second, Lisa. Okay.
Okay, I have a question of the proponent.
Go ahead.
So there was something I saw in the writing about the possibility of setback reduction to the north or south. Is that true? Or did I misunderstand that?
I can answer that. What the discussion focused, and Jay, if it's possible to bring back up the site plan, that would be great. But what staff was referring to there is that the setback to the south is 15 feet, and we have proposed to meet that setback, but we haven't asked for a variance to that setback. And Jay, if you could bring a site plan photo up and then point out, yes, that would work. That one works really well right there. So you can see Nanana Avenue. And Jay, if you could put the cursor right where the 15-foot setback is, you can see it right in that area. It is conceivable that we could ask for maybe another 10-foot setback to go further to the south, which would have some reduction in the oceanfront setback were we to do that. There's really 3 reasons why we didn't do that. One, as you can see from the topography, the only flat part of the site is in that area. So if we did that, we would have no yard at all. And we're going to have a really small yard anyway. It's going to be, if you factor in where the driveway is, the yard is 15 feet by 15 feet. It's a very small front yard, and we didn't want to reduce it to nothing. The second reason is that it also would force us to redesign the driveway in a way that would make the driveway more steep, because we have to have a flat approach at the point where we enter the garage. And so, you know, if we put the garage further to the south, then we're going to have to steepen the driveway even more. And you know, granted, the applicant has expressed a willingness to go to that at-grade driveway because the other design was so unpopular, and frankly, the applicant didn't like that other design anyway. But it's already going to be at 35 degrees, which is about the reasonable limit of what you really want. Beyond that, it becomes you know, very difficult to drive up slopes that are, I mean, it's already going to be difficult, but it's going to be even more difficult because you're driving and you really can't see in front of yourself for a few feet in front of it. So it's very much not ideal to have a driveway steeper than 35 degrees. And then finally, we, you know, really wouldn't have that much effect on the neighbor's view to the north. It would give maybe another 10 feet. I'm guessing, I'm throwing out a number there, but it's not gonna, it would result in an increase in their arc of view that would maybe be 1 or 2 or 3 degrees, something like that. It's really not gonna have that much benefit to the neighbor. And so when we factored in all of those things, that's why we chose not to do that. You know, if the Planning Commission were to think that that's a great idea, then I'm sure we would revisit our, you know, our approach, but we would really prefer not to do that.
Well, but in response, I just, first of all, as far as having, you have the whole ocean as your front yard. So, you know, the whole seashore is the front yard of this house, essentially, because you're right smack on the ocean front. So the yard thing I don't quite get, but it would result in quite a bit more square footage. And if that's the big beef here, is that there's not enough square footage in the house, it would seem to me, rather than encroaching onto the oceanfront setback, there are other ways to get more square footage without trying to get closer to the oceanfront setback. That's all I'm saying. I'm puzzled why this is coming up again when, you know, when there are other solutions that would potentially work and wouldn't cause any problems at all for any of the neighbors. It just doesn't make any sense to me.
But the increase in square footage would be actually quite modest. It would be a couple hundred square feet per floor.
400 square feet.
Yeah, so it might bring us up to 1,100 square feet. It's really not what what we were hoping for in terms of a building size. We're kind of shooting for a 2-story building at 2,700 square feet, I think was what the applicant designed. I mean, it would provide us a little bit of square footage, but not a whole lot. It still would be quite a hardship for us, I think.
Well, that's a qualitative judgment, whether 400 square feet is you know, appreciable or not.
And I agree. Then that's what this hearing's all about. I would say that with regards to the ocean being the front yard, I mean, I do sympathize with that to a certain extent, but you know, for example, if you need a place to put firewood or you know, other sorts of things like that you would normally put in your yard, you know, it doesn't make any sense to put those sorts of items on the beach, particularly when there will be probably no direct access to the beach. I would imagine it's pretty steep. I guess it's possible, but you know, that would be a whole nother set of improvements that would have to be made. And certainly that hasn't been proposed yet to my knowledge.
We've also tried to stay away from talking about size of house in one respect, is that when you compare us to the other lots in the vicinity, all of them are able to build out to the maximum potential of their lot. They fill out their floor area ratio. So this discussion about us not being able of getting a few hundred feet here or a few hundred feet there doesn't get us, it doesn't really speak to the fact what the hardship is that we don't have full development. And this is unusual. This isn't like there's other houses in the area that basically had to make a smaller house, as opposed to they wanted a smaller house, but they don't have that capability of doing a larger house. They do have the ability of doing a larger house if they so desire, which in this case, it doesn't exist. And clearly, the Roberts would like to not maximize the floor area ratio, but at least have a larger house, like the other properties in the area are able to do.
Okay, are there any other questions or any other proponents that have anything more to say? Okay, if not, we're moving on to presentations by opponents.
All right, Will?
Hello, can you hear me?
Yes.
Yes, and so Will, I've got Kevin also to speak on behalf. Anyone else on your team?
No, just me and Kevin. So
Okay.
you're planning on, are you planning on splitting 15 minutes between us then?
Yes.
Okay, would you please let me know then when I'm at 13 minutes? If I get to 13 minutes, Kevin, I apologize if I use 13.
Okay.
So, I would say that Kevin should at least get 5 minutes there. So, but hey, Will, are you going to share your screen?
No, not planning on sharing the screen. I'll read a couple of pages in the supplement that you recently distributed to the Planning Commission.
Okay.
So, hello, everybody. For those of you who don't know me, I'm Will Rasmussen. I'm a land use partner at Miller Nash, Graham and Dunn. Address is 111 Southwest 5th Avenue, Suite 3400 in Portland, Oregon, 97204. As shown in the record in our prior meetings, I represent Haystack Rock LLC, the owner of the abutting property to the north, the Oswald West Cabin. As we've documented in our prior proposals, the Newport family, who owns the Oswald West Cabin for decades, have been big proponents of efforts from the city and efforts from historical groups to preserve the Oswald West Cabin and preserve and create Inspiration Point, help acquire that for the city, and generally preserve the character of this part of Cannon Beach. It's very important to their family, as it is very important to the residents of Cannon Beach and the people of Oregon. I'm not going to rehash the variance approval criteria. I know this Planning Commission is very familiar with them and also familiar with the fact that it's a very high standard, a very hard to meet standard that's rarely granted in Cannon Beach and similar jurisdictions. I hope to focus instead on 3 points regarding specific approval criteria at play here. First, that the applicant identifies no unusual practical difficulties or unnecessary hardships. Just wanting a bigger house is both common and not a hardship. Second, that the requested variance would contradict important comprehensive plan policies. And third, that the variance would injure nearby properties by blocking views and jeopardizing the dewatering system that stabilizes the S curves. That the view issue both exists for the Oswald West Cabin to the north and Inspiration Point to the south. By way of background, applicant's property is due west from the northern end of the Hemlock S curves. The property sat undeveloped for decades because of its unsafe location, lack of access, steep slopes, geotechnical instability, and the restricted building area from the oceanfront setback rule. As staff has pointed out, the oceanfront setback has been codified in Cannon Beach since 1994. Applicants bought their first half interest of the property in 2001 for $150,000, and then bought the second half of this property in 2016 for $35,000. Applicant now requests a variance to disregard the oceanfront setback requirements. On these facts, there's just no reason to grant this variance. Moving to the specific approval criteria, under the first variance criterion, applicant must show that there's a quote, practical difficulty or unnecessary hardship, as is adequately documented in the record here. Applicant argues that a 1,400 square foot home is too small. In applicant's words, this would be, quote, an economically unviable home, and that the smaller residence, quote, does not provide any reasonable return on their investment in this lot. Those are just not the variance approval criteria. Applicant argues for too much. If a 2,600 square foot house is required for this lot, the same thing would be required for every lot across Cannon Beach. And as I'll discuss in the comprehensive plan section, that's just not what Cannon Beach envisions for its city. Staff aptly pointed out in their October staff report, which we resubmitted into the record, that this would be in the 45th percentile for home size in Cannon Beach. 1,400 square foot home is plainly normal in Cannon Beach. It's also consistent, as staff points out in this most recent staff report, with other beachfront homes, including beachfront homes in the Haystack Rock area. In fact, if the Planning Commission were to approve this, applicant would receive a windfall by converting what's a not buildable lot into not only buildable, but buildable with a very large home on it. There's multiple development constraints that have existed on this property, including the oceanfront setback, since well before applicant acquired it. We're also submitting into the record several comparables from the time applicant acquired the second half of this property to show that it would have cost applicant 4 to 10 times this amount to buy this property if it were in fact a buildable lot. And that's not even factoring that the view and seclusion of this location in fact makes it much better than those comparable properties. In any event, applicant's inability to realize a windfall on this lot with long-standing, long documented development constraints is not a, quote, unusual practical difficulty or unnecessary hardship that warrants a variance on the first criterion.
So Will, your audio is not coming through to
Let me try. Can you hear me any better now?
yeah, but
I'm going to try.
you keep fading out.
Yeah, it's coming in and out, Will.
Gosh, dang it. Well, I'm going to sit really close to my microphone and hope it works better for this next section. If it keeps cutting out, will you let me know? And I can dial in by phone and let Kevin do his thing and patch back in.
Yeah,
go ahead.
All right. The second point I want to hit on the criteria is that the oceanfront setback is consistent with the city's comprehensive plan. The variance approval criteria, as the commission knows, had two components relevant for the comprehensive plan. First, imposition of a code standard must be inconsistent with the objectives of the comprehensive plan to grant a variance. And second, non-enforcement of this standard actually has to support policies contained therein. Neither of these requirements are met here. In addition to there being zero comprehensive plan policies actually supporting this variance, several policies advise against it. Housing Policy 1, for example, states that in order to maintain the city's village character and its diverse population, the city will encourage the development of housing which meets the needs of a variety of age and income groups, as well as special needs. I'll just say the city's village character is not defined by large homes encroaching into the oceanfront setback. Similarly, Housing Policy 6 states that the city recognizes the importance of its existing residential neighborhoods in defining the character of the community and will strive to accommodate new residential development in a manner that is sensitive to the scale, character, and density of existing residential development. As is plain on the face of the oceanfront setback in its intent section, the setback protects the character of existing residents and prevents kind of a race to the west, if you will, of new homes blocking the view of old homes and preserves some of the natural character that's existed in Cannon Beach forever. Similarly, the proposal is completely silent on comprehensive plan policies 1, 2, and 3 for hazards. These policies are to minimize risks from known hazards such as geotechnical instability and oceanfront winds and wave. The oceanfront setback explicitly mitigates this risk, and the application is silent on these policies. Likewise, it's silent on policy 11 in the recreation, open space, Natural, Visual, and Historic Resources section of the comp plan. That states that vegetation and tree cover along the ocean front shall be managed in a manner which retains its erosion control capabilities and maintains its contribution to the scenic character of the beach. Moving this home additional 30-some feet into the oceanfront setback hurts the scenic character of the beach. Lastly, and Kevin's going to mostly talk about this, the approval of the application would injure nearby properties, including city-owned Inspiration Point. Kevin submitted a letter into the record, which applicant kindly put up on the screen, depicting the impact of this proposal on the view from the historic Oswald West cabin. When he talks about that, I'd reference you to pages 9 and 10 in the staff supplement from today if you want to see those images on paper or in your screen, however you have that saved. I'll let Kevin talk about it, but I'll just take a moment to rebut applicant's attorney's statement that that exhibit is devoid of science or reality. The coastline actually runs south-southeast here. And you can see that in all the aerial photos of this site. Applicant proposes to jump out west of my client's property by 30-some, yes, this exhibit, by 30-some feet. Then applicant claims that that's not going to have any impact on the view of my client, or a negligible impact, again, to quote applicant's attorney, by doing so. I do not understand how physics could possibly work if one landowner along beachfront property is allowed to jump further out towards the coast and not impact that view. The view arc exhibit that applicant put up in its presentation today, I believe this is third iteration of that exhibit we've seen so far in the various proposals from applicants here. And it's interesting, each time I see a new iteration of that exhibit from applicants, the impact of the arc to the south for my client's property seems to magically shrink. We submitted the first example of that view arc that they first submitted, and somehow every time it comes back, it shrinks. I just don't know with the rules of physics how one owner could be allowed to jump further west into the view of another without impacting their view. It's relevant for this particular site because the Oswald West cabin is a National Historic Site. So it's both impacting the view from the cabin to the beach and from all beachgoers to the south towards the cabin. The cabin is part of the historic character of the city. It's part of the historical character of Haystack Rock, and we want to preserve that. I will stop on the criteria right there. I have one more point I'll just throw out there if I have a minute.
Go ahead.
There's an unknown access component to this proposal. As applicant said, well, we had this prior proposal that our engineers put together, and I believe Karen Labonte, Public Works, says, oh, try to make it closer to the ground, and they say they're going to try to do that. I think it would be unfathomable if the city would actually consider approving something here without knowing what that access is, where it's coming from, how it's impacting the oceanfront overlay zone, how it's impacting the vegetation in the area. And the Planning Commission needs to make clear one way or another that applicant needs to go through a public process regarding that access. I will yield the rest of the time to Kevin if he could use it.
Go ahead, Kevin.
Okay, my name is, my name is Kevin Newport. I live at 4332 Southwest Summer Way, Portland, Oregon, 97221. Good evening. I wanted to make a couple of additional points to my written letter, which is in the supplemental packet materials dated 2/25/21, D5 for reference. As my letter states, I'm one of the owners of the historic Oswald West log cabin. It's been 52 amazing years after the 1991 fire. The cabin was in jeopardy of not being rebuilt. I'm so glad it got rebuilt. The reason for sharing the short story is the applicants think we should have built the cabin closer to the ocean because we could, and that's true. The simple reason why we did not was because we replicated the original house and it got approved and recognized on the National Register of Historic Places. What does that mean? That means as one of the requirements to have the designation, our family had to post the event publicly and open our doors to the community and the Cannon Beach visitors once a year for 15 years, once a day, 1 day out of the year for 15 years. We would routinely see upwards of 500 people go through the house and enjoy the significant 180-degree south and north views. It gives us great pleasure to share the historical property with the public. To this day, we now participate with the Cannon Beach History Center and the museum's annual cottage tours when we are invited. So this isn't just about the Newport's family. It's about sharing Governor Oswald West left us, Cannon Beach community, and all of its visitors. To the history buffs and the common folks, it means something, and it means something to our family. Lastly, I'd like to go to page 4 of my letter, D5 in the supplemental packet dated today. And the applicants are correct on the design of the rendition that I put on the screen. It is not to scale, but I would certainly challenge the applicant to put theirs to scale physically on the property line that they are proposing, because our entire south view is 100% obliviated by a 2,400 square foot home, by a 2,700 square foot home. It doesn't matter which rendition you're looking at. The rendition of the Roberts house was used to illustrate the injurious and complete blackout to the south. To this day, we can see the Silver Point and Jockey Cap unobstructed. For 75 plus years with our ownership of the family has enjoyed the same view Governor Oswald West had back in 1913. So to sum it up, the view hasn't changed in 108 years. That's history, and it's significant to the entire Cannon Beach community and all of our visitors. Tonight, I ask the City of Cannon Beach commissioners and staff to recognize this and follow the comprehensive plan, and more importantly, the ocean setback line, and deny the variance. Thanks for your time.
Thank you. Are there any other presentations by opponents?
We have one, I think Jan wants to speak. Jan, are you there?
Hello.
Oh, hi, Jan.
Hi. Yes, I would like to read a brief letter from myself, Jan Siebert Warmond, and my husband, Wes Warmond. P.O. Box 778, Cannon Beach, Oregon 97110. Dear Cannon Beach Planning Commissioners, it is our understanding that the Roberts are once again attempting to resist following the required oceanfront setback rules. To our knowledge, the oceanfront setback rules help to protect our community and our public lands from development that would be detrimental. To put the Roberts development nearer to the beach would negatively impact the vista of both the historically significant Oswald West home and the incomparable Inspiration Point. Building closer could also be a public safety concern due to the instability of the ocean front. We also have concerns regarding the intersection the Roberts are hoping to develop at the S-curves, which could make that stretch of road even more dangerous than it already is. Finally, we urge you tonight to deny the Roberts' request for a hardship variance. The oceanfront setback rules need to be followed. Thank you.
Thank you. Okay. If there are no other opponents, we will continue with the staff response.
Yes. First, one thing I would like to do for everyone, because we're getting requests about meetings, and since we're still doing Zoom meetings, I'm sharing my screen to show everyone, and I want to do this probably at every meeting. If you go to the city's website, every Zoom meeting can be found, the Zoom meeting codes. If you go to the agendas and minutes tab, click on it, go to the meeting that you're wanting to go to, and tonight's 2/25/2021, go to the view details, and there's the Zoom meeting code for every meeting that the city holds. So we often get requests that, a last minute request that they have not seen the Zoom meeting come out. You can always get to it and to our materials at this agenda and meetings. That's where we'll also put all of the latest packets, and you can see the latest addendum packet right here. And then once the details of the meetings and the live recordings are there. But as far as any other, I'm going to stop sharing my screen now. As far as staff feedback, I think I'll wait until I get the new materials out to everyone, and then I'll put an addendum to that or a second staff report to that to speak to any questions.
Okay.
Oh, yes, Andrew gets to respond there.
Yeah, I know. Does the applicant or proponents wish to add additional statements? And if you do, you're limited to 5 minutes.
Oh, sorry, just 1 second.
Okay, thank you. Okay, I'll be real brief in the interest of time. The opponents mischaracterized the nature of our application, the hardship that we identified. What we said was that the buildable footprint for this property is the hardship, is the special circumstance. And everyone's kept talking about the size of homes. Well, the size of homes is irrelevant because you can always tear a home down and build a new home. And it's those development rights that we're talking about here. And frankly, in most of the homes in Cannon Beach, particularly the ones that are on the ocean front, the homes themselves are basically tear downs, except for the newer ones. The older ones, I did analysis of it. The lots are worth upwards of 5 to 6 times the improvement values of that 1950s bungalow. And in those situations, that's a tear down house. And if you tear down the house, you can build all the way to the setbacks. And so that's what we're talking about here is buildable footprint. I heard Mr. Rasmussen talk about this lot being an unbuildable lot. Of course, there's no evidence in the record that it's unbuildable. He hasn't submitted any evidence. He doesn't have any evidence. He's just saying that out of thin air, hoping that if he says it enough, you'll believe it. The truth of the matter is the lot is buildable and it will be built on. Someday, somehow, there will be a house on that lot. That's just the reality of things. So I'd really appreciate it if people would stop talking about this lot as being unbuildable. Next, we talked a lot about housing. He talked about a lot of comprehensive plan policies that he says doesn't support the development. He makes rather tenuous connections to things such as village character. Well, I've been to Cannon Beach. I saw the Chapman Point homes, and I can tell you that's not village character. I love Cannon Beach's village character in the center of town and closer inside. But when you're talking about some of these low density areas on the edge of town, the dwelling that's proposed by the applicant is no more, no less consistent with village character than anything else you've approved in the last 20 or 30 years. Mr. Rasmussen also talks about various hazards policies, but he doesn't submit any evidence to suggest that we don't meet those policies. And in fact, we submitted expert testimony from Mr. Don Rondema, who's done lots of work for the city of Cannon Beach, that suggests, as staff said, that we will make the situation better, not worse. So all this garbage about hazards is just that. It's complete garbage. Will knows it. He doesn't have any evidence. That's why he's just basically talking out of the side of his mouth. Finally, he talks about injury to neighboring properties, and he says that we'll move the dwelling 30 feet closer than his client's property. I don't know where he gets those numbers from. Those are unsupported by the record. The only expert testimony in the record is what we presented today. Everything else is just crayons written by children, frankly. And even one gentleman admitted that his drawing wasn't to scale, which leads to the question of why would you even submit something if it's not to scale? That's ridiculous. You know, and frankly, I think it borderlines on being unethical for an attorney to even suggest that evidence is relevant. It's not substantial evidence, and it shouldn't be presented. And frankly, it just kind of angers me that someone would suggest otherwise. So what we've done is drawn to scale. We can't get on the neighbor's property unless what I heard tonight was permission to do so, in which case we can give you something even more precise. But without going on the neighbor's property, we can't ever provide a perspective photo montage that's going to be 100% accurate. Just can't do it. And so we've done the best that we can. We think we're accurate within probably about 5%. Certainly, the views that we show in our photograph, we will stand by those assessments. They are correct. And the views of Jockey Point and those rocks that are out in the ocean that they talked about will remain. So, you know, what I'm telling you here today is that there is no major impact on the views to this from properties to the north. On the other hand,
Your time is coming to a limit.
okay, thank you very much, sir. In any event, I didn't hear anything tonight from the opponents that would justify the denial of a variance. I think we've made a pretty good case that we have a very unique situation here, 73% reduction in buildable footprint resulting in a house in low density residential land that would really only lead to about a 1,400 square foot house is really not reasonable considering we have massive amounts of improvements that we need to do, including stabilization to the hillside and also a very difficult access location that we have to engineer very carefully to make sure it's safe. I think this is a prime candidate for approval of a variance. And I thank you for your time tonight.
Okay. Is that?
I'll let Bill. Hey, Bill, I do have one question, Bill.
Yes.
I've worked in other areas of the country, and in other areas of the country, they'll request story poles for building envelopes. Do they do that in Oregon? Is that a general requirement or?
Story poles?
Yeah, like in Idaho, we would request for a new development that they put up story poles, which are pretty much just like a timber structure kind of that shows the envelope at the actual scale at the site.
I want to make sure I heard you. Typically, I haven't seen that. We certainly could request that if that's something the Planning Commission wants to see. You know, that's one option. I do want to note that in reviewing the documents that there was a request made by Mr. Rasmussen in his letter to keep the record open. So after we go through any questions the Planning Commission might have, we can talk about what you want to do, whether you want to continue the record, continue the hearing, or have a scenario like we've done previously of 777 open record periods.
Well, the issue is going to be continued, but definitely we've got to wrap up this proposal. So whatever we need to take in order to get the additional records submitted and make sure that we don't continue this process through next month's meeting.
So what we've used in the past and the statutory framework that's set out is to allow 7 days for any participant to submit any new evidence and argument that they want. Then 7 days after, and that would take it to, let's see, close of business March 4th. Then 7 days beyond that for anybody to respond to the new evidence that came in during that first 7 day period. That would take it to February 11th. So that second 7 day period would be only responding to what came in that first 7 day period. And then a final 7 day period for the applicant and the applicant alone to submit written argument with no new evidence. And that would take it to March 18th. And in the past, you've allowed limited oral argument at your second planning commission hearing of 3 or 5 minutes, I can't recall exactly, with no new evidence. And if that seems to have worked well, but you could also make some tweaks in that formula if you'd like to.
Well, I definitely would be limiting the presentations to 5 minutes in the next meeting.
Do we have to have oral argument? I mean, is that a requirement?
No, you don't. You can limit it just to the written record.
I would ask that we limit it to the written record.
I would agree with that. Do the other commissioners have any feelings about that?
I agree with both of you.
I agree as well.
I do too.
As well.
Okay, so we're limiting it just to written records, no oral arguments. So in that case, we will.
Yeah, unless there are any other questions from the planning commission.
Okay, if there are no other questions, then we will continue on.
And so that continuance, just to make clear, would be a 7 day open record period until March 4th, a 7 day responsive record period on March 11th, and a 7 day period for the applicant to submit final written argument on March 18th, with the matter being continued to the Planning Commission's next meeting, which is scheduled for March 25th at 6 p.m.
Correct. Okay. In that case, we will continue to the informational items. Anybody have anything to say about the tree report? Ongoing planning items?
We did get the approval for that code audit, and so we're moving forward with an RFQ that was just posted on that request for qualifications. That's out and posted. We expect to close that, I think, in a couple weeks. We also have the transportation system plan that will is targeting for the first open house in April, I believe. And so that's coming together, and would still open spot for a planning commission liaison for that committee. So if there's someone on the planning commission that would like to meet, I think it'll be probably about monthly on that. Please let me know or let the chair know, and we can talk about that.
Okay. Okay.
I have a question.
Yep, go ahead.
This may be along those lines. Jeff, will you revisit the conversation, excuse me, the email you sent out where we were going to comment on, I wasn't clear whether staff comments you were going to touch on or whether that was our reviewing the notes, or how the notes were taken on our behalf, how we were coming back to that. I'd like to be clear on that, how we're going to move forward.
Are you talking about for findings?
Yes.
Yeah, so Clay, we have proposed a new script for the chair and for you all for motions, so that you would tentatively approve, and then we would come back the following week at 6 p.m. the Thursday following your all's meeting. So I think the next meeting's on the 25th. So the following Thursday, we would gather and go back through those findings after I type them up and get them out to you guys.
So are we commenting, when you have those findings, you will, let's take the Gary's Towing Service. You made certain comments and findings in there. Are we commenting on your comments, or are we commenting on what we said in the meeting?
Yeah, so I will draft up just as I present to you guys, a draft form of the findings of the staff report. I will collect whatever you guys decided and refine what that said to that. And then so you will be commenting on that, what transpired in that meeting.
So hopefully what Jeff will bring back to you is your comments in the meeting as well as, previous stuff in the staff report. And then when you look at what Jeff brings back to you in those findings, it should reflect the Planning Commission's views of the right way to interpret the city's code that's at issue and the arguments made by the parties.
So if we don't agree with something, the way Jeff has interpreted code, we can air that and that can be revised?
Yep.
Okay.
Right, yes.
Okay.
That's what that would service, is that provide you guys the opportunity to review what I typed up.
And as a matter of procedure, let's say we don't agree as a body on the interpretation of a particular section. When are we voting on it and that second call, on that follow-up call, or how are we procedurally coming to some sort of consensus on what we put in the findings?
When you're reviewing the findings, that would be when the Planning Commission would come to a decision about how a particular piece of code would be interpreted or whatever that issue may be. And there may well be a dispute among different planning commissioners, and it would be the majority saying, no, we think, we measure from the ground surface or from, whatever the dispute may be, would be at that meeting.
Thank you.
Okay. Anything for good of the order? Okay, if there's nothing left, then we are adjourned.
All right, thank you all.
Thank you.
Bye.
Bye.